Assalamualaikum. Okay, I'm Nabilah as your host for today. Okay, today we're gonna talk about one of the element in the company law, which is constitution in the company. Okay, so what is the constitution in the company? Constitution is the document that generally specifies the rules governing between the company and the members. In this constitution, there are several items that the company may need to follow and how it can assist the company to form a new company. Okay, so we are going to interview a few workers of Company Commission of Malaysia, also known as CCM, to know deeper about the constitution of the company. Hello, Miss Anis. Can I have a few minutes with you?
Okay,
Okay, so the first question that I want to ask you, it is necessary for a company to write a constitution?
Actually, it is not necessary to have such constitution for a company. But as stated under Section 31, constitution is only optional. Under Section 619, subsection 3, if it exists, it's deemed to be adopted under the Act. Only company limited by guarantee shall have a constitution. The constitution shall have MOA and NOA. MOA is Memorandum of Association and AOA is Article of Association, which is there are like internal document in the company that guide what the company can do or cannot do and how it should do it when running the company. And once adopted, it becomes an agreement between the company and shareholder. Each shareholder owes a duty to the company for the rules that being agreed with the company, and the company also owes the same to the shareholder.
Hi, Miss Haida. Yes. Can you spend your time for me?
Yes, please, have a seat.
Miss Haida, yes. I just interview Miss Anis about the necessity of the constitution in the company. So can you explain further about Memorandum of Association?
Sure. So the Constitution may contain provisions relating to the objects of the company, the capacity or the power of the company. If the provision restricts such capacity, since the Company Acts give unlimited capacity under Section 21, the company include matters contemplated by the Act and also any other matters that the company wishes to include. But as for a company limited by guarantee, as it is compulsory for them to have the Constitution, they must state that all that I've mentioned earlier, and also it must also state that the company is the company limited by guarantee, and also the numbers of members which the company wishes to incorporate it.
As you mentioned earlier about the object of the company in the constitution, but I don't quite understand yet. Could you please explain me details about that?
So object clause can be classified into three types, which are main objects, dependent objects, and the power. So main objects are the specific activities engaged by the company, while dependent objects are unspecified additional activities that the company are engaged to together with the main object. As for power will enable the company to achieve its main and dependent objects. Powers can be further classified into three types. Those powers are powers that are conferred expressly by the memorandum of the association, powers that are implicit and incidental to achievement of objects, and powers inferred by the acts.
Oh, so what will happen if the act is ultra-virus?
Good question. Under common law, any act or transaction which is ultra-virus is void and do not bind the company, and it cannot be ratified by members.
Excuse me,
Yes?
sorry for this delay. Can you complete this by today?
Yeah, sure. Oh, sorry. Hello? Oh, okay. I'm sorry, I have a meeting to attend to. Can you continue my session, please?
Okay, what's your question?
Is the ultra-virus is applicable in Malaysia?
Oh yes, of course it is also applicable and recognized in Malaysia too, through the Section 35, subsection to subsection A. So the Constitution cannot contravene the Companies Act. In the Constitution, it have the position of a third party. Section 39, there is non-application of doctrine constructive notice, which is being used to protect against the third-party position.
Okay, after I heard all the explanations, there is a difference in doctrine of ultravirus and the common law and Malaysian law. What is AOA?
Okay, so AOA is a regulation concerning with the internal management of an accounting company.
Okay, so does the company needs the article of association?
Well, actually, under Section 31, Subsection 1, not every company needs a constitution or an AOA, as we know, because company limited by guarantee is the only company that needs the constitution, and they need to lodge their AOA to the registrar of the company. But under Section 31, Subsection 3, it says that if the company doesn't have constitution, they can refer to company's agreement to know their obligations, their duties, powers and rights.
What is the legal effect of the memorandum of association and article of association?
Right, so in Section 33, Subsection 1, it says that when MOA or AOA, as I called it, is adopted, it actually binds the company and the members together as if they are sealed by each other to meet the provisions in the Constitution. Okay, so there are three effects. The first one is the contracting the members and the members. This is where a member can enforce rights to the other members into doing something within their capacity. For example, like the case in Rayfields versus Hans, where it is stated that if one member wanted to sell or transfer shares to the other members, the director needs to buy that shares. But in Rayfield's case, the director refuses to buy his shares. So Rayfield brought it into court, and then the court said that the director need to buy that case because it is stated in the AOA. Okay, and then the second one is the contract between the company and the members. Now this is where it actually binds the company and the members together. Okay, this is because in Hickman versus case, Hickman, it stated that in their company's constitution that if there is any disputation, it needs to be referred to arbitration, which means that the problem needs to be resolved outside the court. But what Hickman did, he brought it into court, and then the company refused to give cooperation because it's not their responsibility. So then the court held that the disputation needs to be referred to arbitration and not the court because it stated that in his contribution. Now the last one is the legal facts between the company and the outsiders. Now the outsiders has nothing to do with the company, so they have no part in the constitution, so they have no rights into giving any obligation towards that company.
Okay, thank you Alya for your time and cooperation. Okay, so now we know that not all company compulsory to have this article, but only company limited by guarantee, and we also know the legal effect of memorandum of association and article of association. constitution?
Under the new provision of the Companies Act, it may alter the constitution by the special resolution, or unless it is like constitution itself is prohibit that the constitution is altered under the section 36 subsection 1.
Right, so how it can be done?
The constitution can be altered by a special resolution, such as it will be approved and 75% of the shareholders, and also given notice not less than 21 days under section 292 subsection 1.
Thank you, Ms. Afieqah, for your cooperation.
Welcome.
Okay, so as a conclusion, the constitution of the company can be altered by a special resolution.